play a pivotal role in protecting the rights of these marginalized and enhancing their access to justice in the various justice systems, both formal and informal. I was asked what Egerton means. I want to leave that to in the previous, I used to see in the TV, somebody from Aseni, he used to be called Wordmaster. He could explain to you how to pronounce things. Whether it is Egerton, whether it is Egerton, I want to leave it to you, to your tongues, how it comes to you. For me, I'll proceed Egerton. So Egerton University Management is proud to be associated with the legal aids and services offered by our faculty of law. With the support that they are getting from the European Union, the UNDP, and also the Amkeni wa Kenya project. Through this support, the university was able to reach out to many and facilitate the access to justice during the pandemic. And this was through many various ways in collaboration with other stakeholders in the justice sector. This service is anchored in our university vision of becoming a world-class university for the advancement of humanity. This is implemented through our law. This is implemented by our Faculty of Law Legal Aid Project, which is acronym FOLLOP. Which envisions justice and equality for all. Deliberating on issues of access to justice in socioeconomic crisis in the context of COVID-19 pandemic. This conference is important not only for academic discourse, which we shall be engaging in, but also in shaping discussions around the direction the country needs to take and look in rebuilding our economy. I wish to thank our sponsors, the European Union, the UNDP, for the important work they do in promoting access to justice for the poor, the vulnerable, the marginalized populations, through the various programs they have in the country that have just been shared a minute ago. Throughout the pandemic, they provided support not only to our project, but to other entities, including governments, to respond to the global pandemic to prevent infections and minimize the spread of the disease. In particular, government interventions such as restrictions of movement, lockdown, curfews, were imperative to secure livelihood. and maintain legal order and fundamental rights of all citizens. All these measures have implications for access to justice for all. However, the marginalized and the poor were disproportionately affected due to their socioeconomic status. As we reflect on the theme of the conference, we should be alive to the fact that the citizens are faced with the hardship resultant from the pandemic, and recovery is not going to be instant. Rebuilding the economy after the ravage is an uphill task for both citizens and the government to restore the justice aftermath. We as the citizens have a duty to help, a duty to shape the government as they rebuild the economy in many ways in the space we occupy as scholars, practitioners, administrators of justice, policymakers, civil society, and members of the private sector that are represented here and without. COVID-19 is not leaving us soon. We have to learn to live and adapt to this menace. Today, let us have an open discussion on how we can collectively develop innovative strategies to improve the well-being of our society and rally support to the citizens and our government to ensure access to justice at all times to everybody. I'm hopeful that the outcome of this conference will shape policy and legal responses that are amenable to all. This is our collective primary goal as responsible citizens. Ladies and gentlemen, once again, I want to thank the European Union and the UNDP for their continued support to our university, the legal aid project, and our faculty of law, and making it possible to host this timely conference. Finally, allow me to appeal to the organizers and sponsors of the conference to ensure that the dialogue started a year ago and running into its second year be made an annual event. For the scholars and those in the justice sector to deliberate on access to justice issues, which we need to strengthen the collaboration among and between the actors. Participants, I now wish you a fruitful deliberations and I remind you to keep safe all through. Thank you all.
Because of her tight schedule, we're going to invite Justice Helen Wasilwa to come and give us the first keynote address. And this is going to be a very good presentation because it's a representation of the judiciary's voice in all this question about access to justice. So, access to justice dimension from a judicial perspective. Justice Wasilwa is a judge in the Environmental and Labor Relations Court. She's a great champion of alternative justice system. She holds an LLM in law. Of course, she says she's a mother and a lover of the administration of justice who has passion for children and women matters and affairs. Welcome, Judge.
Thank you very much, Dr. Miawa. I hope I made that name properly, I pronounced it well. Okay. It is like Yawa. I just added there an M. So it is a pleasure for me to be here this morning, ladies and gentlemen, and even we have been invited to participate. The Chief Registrar of the Judiciary was not able to come as indicated by Dr. Aura, and she requested me to come on her behalf because I'm within the county of Nakuru, where Naivasha is today. So without taking so much time, I will go and make my presentation and just put it right, because I'm with the academia, I'm with the learned men and women, and I'm afraid of making mistakes when I'm dealing with the academia. So because I didn't want to talk off the cuff, I decided that I'll put what I want to say in writing. So let me go straight to what I've written and proceed today. So ladies and gentlemen, it's a great pleasure to join you today as we officially open this conference, which brings together policymakers, scholars, duty bearers, human rights defenders, social justice centers, development partners, and other stakeholders for deliberation under the theme Access to Justice and Socioeconomic Crisis, Lessons from COVID-19 Pandemic. And it has been said by scholars that justice is the oxygen of a free society, and without justice, we do not have a life worth living. For this reason, access to justice and the right to fair trial are protected under the Constitution, statute, and treaties. The discussion around access to justice is therefore an important one, and one that is mandated by our Constitution. So coronavirus, we are dealing with this issue in terms of coronavirus, COVID-19. Coronavirus is a typical black swan event. The global coronavirus outbreak has led to destabilization of the world economy, a loss of earnings for companies as well as individuals, rise in unemployment rate, and significant drop in the stock markets. This pandemic caused lockdowns in numerous nations around the world, including our country, which the president, in the bid to curb the spread, ordered for cessation of movement from the disease-prone areas such as Nairobi, Mombasa, Kilifi, and Kwale. Soon thereafter, there were nationwide curfews that almost brought the Kenyan economy to its knees. And maybe I can just add that as the president ordered cessation of movement, and occasionally there was people coming back, there are also individualized lockdowns. Like in the stations, we'll find that maybe one staff is already sick, a magistrate is already infected. It will be hard to have worked. And therefore, even in the courts, we are definitely affected not only by the nationwide lockdowns, but also with the local lockdowns that had to be done at station level. It is rightly observed that the COVID-19 crisis has not only caused immense harm the world over by not only bringing down the economies, but also caused adverse impact on many businesses and professions, and has immensely affected access to justice the way we know it. It was rightly perceived that the COVID-19 will bring the entire world to a near standstill, and Kenya's justice delivery system is no different. Official data shows that while the institution of new cases, both in the superior courts and the subordinate courts, including the tribunals, had significantly reduced since the beginning of the nationwide lockdown on 6 June 2020. The disposal rate has also severely been affected due to the forced closure of courts. The judiciary has come under immense pressure to innovate strategies that balance public health concerns with access to justice. In this regard, all levels of courts, including the Supreme Court, the Courts of Appeal, the Court of Appeal, the High Court, and the subordinate courts have been operating in a highly restricted manner, with most courts persisting with a restricted functioning. The COVID-19 crisis, however, came at a time when the focus had already been accelerating on setting up of the e-courts and the digitization of justice and court administration. This journey of integrating digital technology in administration of justice began in 2005, and this is evidence from the Judiciary Strategic Plan of 2005 to 2008, which identified court records management systems, CRMs, and digital audio recording, DAR, as key in improving service delivery. The strategic plan unveiled in 2009 also had plans to institutionalize appropriate ICT facilities to increase efficiency in judicial operations. During the term of the former Chief Justice, Dr. Willy Mutunga, harnessing digital technology to expedite delivery of justice was identified as one of the pillars of judicial transformation in the Judicial Transformation Framework of 2012 to 2016. The strategic plan mandated the judiciary to develop and deploy the electronic case management system, digitize court records, and adopt audiovisual recording and transcription of court proceedings. Dr. Willie Mutunga also established the Integrated Court Management System, ICMS, in 2014 that developed the ICT Master Plan of 2017 to 2022 for the judiciary. So the current strategic plan dubbed Sustaining Judicial Transformation for Service Delivery in 2017 to 2021 aspires for quality service delivery through automation and digitization, among other strategies. So the courts have been quick to embrace the use of digital technology in the dispensation of justice. So the practice directions on electronic case management were gazetted on 24th of March 2020 through the Kenya Gazette Notice number 2357 under the Civil Procedure Act. The system, which was developed by the Judiciary Information Communication Technology (ICT) Directorate, was officially launched in July 2020 by the then Chief Justice David Maraga, together with the Office of the Director of Public Prosecutions. The use of digital technology thus proved to be a crucial, innovative solution to ensuring service delivery in the face of coronavirus pandemic. Prior to the launch in 2020, the court case management system had been piloted in Eldoret Law Courts by the National Council for Law Reporting in 2011, while virtual courts were piloted in Nairobi and Mombasa in the same year. The judiciary intended to use the lessons learned from the pilots to inform the piecemeal rollout of ICT integration in 2012 to 2016. This integration was slowed down by inadequate digital technology infrastructure such as computers and internet connections and unreliable electricity in many courts. Ladies and gentlemen, to this end, I'm delighted to share with you some of the progress that we have now made to simplify access to justice for the public, the general public. So digital technology has not only made it possible for courts to operate while complying with COVID-19 prevention protocols, it has also made courts procedure and proceedings more transparent and efficient. You can imagine if I'm sitting online and I'm hearing a case, I don't know who is really watching or who has signed in. So I'm always very alert and careful. Maybe I'll not be quick to say a careless word or a statement. So it has made courts more transparent in the way we deal with issues. And they are also recorded, and therefore, if there was a dispute on whether what was said is not the truth, we can go back to the records. And therefore, it has made the proceedings more transparent and efficient. So the links to virtual courts are shared with the public. Thus, a wider public is privy to the hearing, enhancing the transparency of proceedings. Digitization has also enabled the judiciary to be more accountable as it avails all necessary information to the public through their website and even social media platforms. Electronic and mobile payment of court fees was also established by the Electronic Case Management System, and the Judicial Financial Management Information System also increases accountability and transparency. So nowadays you pay everything. You pay the money for filing the case or whatever document you are filing. It is factored in, and it can be seen by everybody. It is system generated, and therefore that means there is more accountability and transparency. Efficiency has also been enhanced through reduction of paperwork and potential loss of physical court documents that may delay delivery of justice. Digitization of court records and automation of some of the court processes expedites the determination of cases, reducing case backlog. And I believe it is also true that courts have saved a lot on storage costs and retrieval of court documents that is associated with manual record management. It is also cost effective as it saves litigants and defendants time and resources they will have used in traveling to access justice. It also potentially saves time for police officers. They can actually give evidence virtually. They have time to attend to other official duties. They also get the convenience of not having to transport prisoners to courts the way it has always been. Virtual courts have also reduced the cost of transferring and protecting vulnerable witnesses, thus reducing the cost of access to justice. So if a witness is seated in a corner somewhere and they are online giving evidence, it will not be easy for the witness to be a target. I remember when I was a magistrate sometimes back in Kibera law courts, there will be a witness who will come to court and they tell me that they are afraid to speak because the family of the accused person are outside there and they are waiting to destroy him, to kill him as soon as he leaves the court premises. And I used to tell court, how do we protect this witness? What do we do? And one time it happened that this witness came and said, I wanted to say what I need to say. though my life is in danger, I needed to say it. This witness was gunned down just a few meters from the court. These people were waiting. You went to give evidence against us, and that's happened. So I know it is also a good way of protecting vulnerable witnesses, because the accused person may not know where they are. They could be hiding somewhere under the witness protection, and they can be able to give evidence without fear. Ladies and gentlemen, as much as there is immense progress in improving technology by all stakeholders to ensure smooth running of the system, there are still challenges that we are still grappling with. Let me talk about affordable and secure internet connectivity, which is a potential challenge that tends to be compounded by limited electricity connectivity. Many times, if you were to come to our court in Nakuru, if there is a power outage, the server goes off. The server is the first one to be affected. Then the computers are affected. So wherever you are, the server has gone off. There is no way I'll be connected now to the court proceeding that I was on. Every litigant everywhere is shut off at that particular moment. It may be an outage of 2 minutes, but it will take another restarting of the server for it to be brought. That means another delay of maybe 10 minutes. We sign in, and when we are just still signing in, there's another outage of 1 second. The server is dead. We restart it again. So those are some of the challenges that we are having. The issue of connectivity. In cases where the defendants do not have good internet connection, the ability to fully defend themselves virtually also may be compromised. We have had others who have to go to cyber cafes and they sign in. Of course, the noise in the background, you cannot control who is talking in a cyber cafe. The noise is there, the disruption of the court processes. And of course, there are some people who we may not even be able to see. There was something that was happening recently, and it was brought out in the public by the Law Society of Kenya. The issue of other advocates removing their colleagues from the system, so that when they sign in, they say, "Your Honor, I served them. I can see my colleague is not online. I had seen him here earlier on, but now he's not here." Yet they have been removed by the opponent. That is for the advocates who practice, who engage in sharp practice. So it was there. Those are some of the challenges we experience. So the requirement for defendants to have secure and fast broadband internet and robust information and communication technologies to access virtual courts inadvertently hinders their access to justice and contravenes their constitutional rights. Additionally, the cost of internet is high for most Kenyans. There is also inadequate access to appropriate technology that allows for virtual court sessions. Therefore, this crucial innovation risks leaving behind a significant portion of the population and exacerbate inadequacy in access to justice. So the ability of judicial officers and litigants to effectively use the digital technology is also a challenge. And I believe that the Law Society has been engaged in this area. The Law Society has been conducting commercialized training since January 2021 to litigants on e-filing of commercial cases and litigation through virtual platforms. Continuous trainings and capacity building of judicial officers and litigants on ICT is needed to ensure seamless delivery of judicial services. So there are also other potential threats from cyber attacks that may jeopardize digital technology in courts and compromise the integrity of court proceedings. Let me talk about this challenge that I've really seen from the magistrate's court's perspective. So every magistrate is supposed to be linked to the prison in order for the prisoner who is inside the prison to come online, so that their case can be mentioned or the case can be able to proceed. So if I'm a magistrate sitting in Nakuru, I may be linked to a prisoner who is in Naivasha maximum, or I'm another one who is the other prisons, Nakuru, or maybe is there a prison in Molo, I think. Yes. So you are linked to different prisons. At the same time, there is a colleague, another magistrate in court number 2 or court number 3, who is also linked to the same prison. So this prison officer is supposed to ensure that this prisoner, assuming that they are different prisoners with different cases, they are linked to different magistrates at the same time, being controlled through the prison. It is very, very hard. Sometimes you find that like in Nairobi, where we have from court number 1 to court number 15, and they are all supposed to be linked to industrial area or to committee prison, there is always a delay. It means that courts must work in shifts so that we have court 1, sign in first, finish your cases, court 2, sign in, causing another delay. And also maybe the prison department, I don't know how equipped they are with this technology. They are also justice players. So as much as the judiciary wants to go forward, I don't know whether the prison officers are able to access technology and sign in these prisoners as they come to court to answer to their questions. So those are some of the areas that I see a challenge and which need to be looked into. Although the Office of the Data Protection Commissioner was also established with the aim of enhancing data protection, it mainly safeguards data privacy. Currently, there are no overarching law that specifically addresses cybersecurity issues, as the Computer and Cybercrime Amendment Bill of 2021 is yet to be ascended to. Although video conference is a substitute for physical court appearances, the assessment of nonverbal cues such as the defendant's emotions and eye movement to gauge credibility is limited when compared to physical court appearances, what we call the mens rea. We may not be able to discern, as we are not able to see the parties really physically to be able to know whether they are saying the truth or not. Additionally, virtual court appearances do not allow for proper detection of signs of torture and ill treatment of accused persons. Virtual courts may also potentially skew the criminal justice system against persons deprived of freedom, as they may feel intimidated and lack confidence when they are not able to physically appear before a judge or a magistrate. And this is really common in Kenya, where you may have a simple matter that you can really solve, but somebody will say, we'll meet in court. You'll be hearing from my advocate. People feel proud that this thing will be resolved by a magistrate physically, and they'll be able to show that they were wrong. But now when they are not brought before the magistrate physically, they feel that justice is at a distance. They are not really feeling the justice. Therefore, courts should determine on a needs basis which criminal cases can be held virtually and which ones will still require physical court appearance. Ladies and gentlemen, the existing circumstances are likely to turbocharge the transformation of the Kenyan legal system. The judicial directive of innovating the virtual court system to make the justice delivery system accessible to everyone is a welcome change. In doing so, Kenyan courts have sustained the chief principle of the Kenyan legal system, that is, justice must not only be done, but must be seen to be done. In the present circumstances, arbitration as one of the alternative judicial system, AJS, is expected to be most desired and a versatile mode of resolution of disputes. The challenge of this trying time should be harnessed as an opportunity for the Kenyan legal system to revamp and strengthen the operating procedures to mitigate the effects of COVID-19 pandemic at the earliest. That being said and done, where on one hand, even though a quick transition is the need of the hour, yet on the other, it ultimately will depend on the individual capacity of the stakeholders to adapt and adopt to this dynamic situation. So what I can say in conclusion is to all of us and the stakeholders is that the judiciary and all stakeholders have tried in their different capacities to ensure justice is served without delay. However, there are several areas that still need to be improved as highlighted above and can only be achieved when we work together. And being here, I think one of the areas that we can really work together as we have gathered here and as we go forward is to ensure that all the stakeholders are well equipped. If there is a way of funding to ensure the prisons are funded, the children's officers are able to get the computers, the probation officers, the magistrates, they are all well funded so that they can be able to access the online platform. Improvement of the platform itself so that it doesn't keep going off. Many times advocates say, I've been trying to sign in. I've tried to send this document, but it has not reached the court yet. It is hanging somewhere. So I think improvement of this digital space is very important for Kenya, and I believe it's something that it is here now to stay. You are told that I'll be attending to something. Actually, I'm going to court. I have a small office at the reception, and I'm going to sign in, and the parties will be waiting for me. So it is something good. If it was not there, I'll not be here because I will have told Dr. Aura I'm not able to attend because I have to attend to court. But I told the parties I'll go to Naivasha, and I was in court around 9:30. I read 4 judgments before I came in. I did mentions, I gave directions. And now I can go and hear one witness before the lunch. So it is a good space. It is here to stay, And if we embrace it, it's going to help not only the litigants, but even the advocates. They can be able to sign in from anywhere and be in 5 courts, yeah, instead of being physically in one and you can't go to the other. So I think it's a good space for us to embrace, and the COVID-19 has taught us that we can embrace technology and move forward. So I thank you, ladies and gentlemen, and may God bless you.
Thank you so much, Justice Wasilo, for those key highlights. I think just to rephrase in brief what she presented on, I think she has highlighted, the Honorable Judge has highlighted the menace of coronavirus as a disruption in the administration of justice. She has highlighted how COVID-19 has affected the delivery of justice in Kenya, or the administration of justice in general, and the measure the courts are taking as an adaptation towards that challenge. Of course, the various challenges that both litigants and their clients present in the administration of justice. Some of us go through that all the time, by the way, and especially when there are critical applications where you have to be defeated at all costs. And of course, she's urged finally that there is need for re-equipment or rearmament of all the stakeholders involved. Thank you so much for that presentation. We highly appreciate. We would have had some questions for you, but for your tight schedule, because you are going to engage in another administration of justice, we will let you go. Okay, thank you so much. Then you can preserve your questions for that session at another time, another date. The next speaker is Mary Magure, who is the acting CEO of the Legal Council for Legal Education. She's also the substantive director of quality assurance and licensing at CLE. She's an advocate of the High Court of Kenya, a very good friend of the faculty at Egerton University. Feel most welcome, and we are ready to listen to your incisive sentiments.
Good morning, ladies and gentlemen. It's still morning. The representatives of the UNDP, the representatives of the EU, the DVC in charge of research and extension at Egerton University, my senior, my lady, the Honorable Judge, my senior and friend, Professor Pierre Lumumba, the Director of the National Legal Aid Service, Mr. Abidani, my friend and senior, Dr. Ruth Aura, the Deputy County Commissioner, faculty members of Egerton University, the representatives of various organizations offering legal aid in Kenya, the future represented here by the Egerton University student fraternity and researchers present, members of the fourth estate, if any, ladies and gentlemen. I take this opportunity to make this representation on behalf of the Council of Legal Education, where I am holding fort for the next couple of days until our new CEO reports. Just a little bit about the Council. The Council of Legal Education is the regulator of legal education and training in Kenya. We are responsible for setting the standard of legal education and training. The law allows us to determine curricula and content of legal education and training in Kenya. But we also perform another very important role, which is to administer the bar examination for all those persons seeking to become and practice law within the four walls of the Republic of Kenya. Now, Dr. Urab spent the entire month of November reflecting on what my role is in nation building. What have I done as an individual in service to country? And this maybe has a reason from the fact that November for me is Remembrance Month. I wear my poppy in honor of my grandfather, who served in the Second World War in Burma. And I was trying to wonder the entire month, what is it that I can say I have done for country? What is my role? How have I given back? What can be said to my children about my existence in this country? What impact have I made? And therefore, asking me today on the last day of November to speak a little bit about duty bearers in ensuring access to justice in the provision of legal aid simply just brings all that to fusion, and it sort of just comes together in my mind what the role of the council can be. Now, the Council of Legal Education traverses the entire terrain of the justice sector, mainly because it is where the content of what is taught in our law school is approved and or determined and or given the green light, whichever of it you may want to adopt. And maybe more important is that the council is anchored in the Office of the Attorney General and Department of Justice, specifically in the Department of Justice. And therefore, that just brings together the role, as it were, that in determining the standards of legal education and training, and even as a consumer of advocates that we train, the council really is at the center and actually facilitates the justice sector in Kenya. Now, council has not and was not immune to the effects of COVID-19. You may want to recall that Presidential Directive 123 required us to stay away from the offices, avoid contact, work from home, prevent congregation. We didn't offer the bar for a year because we couldn't guarantee the Ministry of Education how we would bring together 4,000 people and not become an infection bubble. So we were affected by COVID-19. And so when I look at our role as duty bearers in the entire scenario and reflecting on what we are as change drivers in our society, I must say that the overall and overarching responsibility of council to determine and set policy and to determine regulation and implement standards in legal education and training, which trickles down, I must assure you, all the way to the provision of legal aid in Kenya, is one of our key responsibilities as duty bearers in this country. The council also has a role to ensure that what is taught in our institutions of higher learning is responsive legal education that is able to navigate the new terrain, emerging issues, captured and brought in through legal aid clinics, studies like those done by our researchers in this role, comparative studies, comparative jurisdiction, we call them milestones, where a jurisdiction has gone so far and advanced the theory so far that it has begun to bear fruit for them. By being able to adopt to that sort of change in society and to be able to reflect that in what is taught in our universities in Kenya, I must surely state that is a responsibility that council bears with its head held high. I want to maybe leverage a little bit on the Honorable Judge's presentation on the issue of ensuring access, because access, when COVID struck, was one of our greatest headaches. In fact, out of the 17 universities that we have licensed in Kenya, only 6 were ready and able to ensure continuity of learning, Egerton University being one of them. The other 11 struggled. Some were sure that they don't have the capacity to deliver their program using technology, and they will not have it for some time to come. And that was pretty discouraging. But even where institutions could offer the platforms, they could not also guarantee access by the candidates, because access to internet connectivity trickles down, has a cost implication. And since universities could not prove to the regulator how they would guarantee that a class of 50 would log on to the platform. Council was also trying to be quite conservative to say, show us how you will ensure, or at least measures you will put in place to facilitate access. Most of them were not able to. And then we had some pretty innovative institutions that actually approached the service provider and said, look, we've got a student complement of 5,000. We would like to be able to guarantee access. Could we negotiate some sort of data bundles that could enable our candidates log on to the systems? Some were able to do that. But that is 6, ladies and gentlemen, out of 17 institutions that made the step. And therefore, the issue of access to connectivity with a cost implication still remains to us today. Even more alarming is the fact that technological skills are not obvious. They are not inherent in all of us. We have to learn. In the execution of Council's mandates, we have a responsibility, actually an obligation, to ensure that graduates that feed into our market today are qualified to do so. Ms. Bidali and I have had endless conversations about who the law defines as a paralegal and what the qualification of a paralegal should be, and to what extent we should trust a paralegal with issues, personal issues, economic issues relating to people who are seeking legal aid. Who is a paralegal? What are the 4 walls? What are these qualifications that we are talking about of who a paralegal should be? I know that I remember, Ruth, maybe we should have that paper come up again. In the last conference, we had actually one of your candidates writing a paper on the disorder, that's a better word, the disorder that exists in the various legislation governing legal aid in Kenya under the National Legal Aid Service, the Advocates Act, a little bit in the Legal Education Act. And I hope that he had quite the proposal going forward on how we should structure that. Because the moment that we are able to structure and define and determine who a paralegal can be, then the Council, the National Legal Aid Service, and the Law Society of Kenya would be able to develop and implement the regulatory framework to ensure that legal aid providers are regulated. Because for all purposes, legal aid providers must be regulated. Because regulation is a quality issue, it's a standards issue, and standards are aged. For us to be able to say that we have a foolproof, responsive legal aid program in Kenya, we must age a standard. We must determine, we must enforce, and then age it to ensure sustainability of legal aid provision in Kenya. The Council, and very many people don't believe me when I say this, does not license a university in Kenya to offer a law program if that university does not run and sustain a legal aid clinic. Now, these legal aid clinics are different depending on the niche areas of the institutions. Some institutions like Egerton do better than others. Some struggle with it. Some take time to determine what it is. Some blend it with some form of public civic education programs. That's okay. There is value in variety. But the fact that the Council does not offer any license to an institution without a legal aid clinic demonstrates, if not solidifies, the fact that the Council is invested in legal aid in Kenya for perpetuity, for purposes of determining that we can guarantee quality legal aid services offered in Kenya. The Council also enjoys responsibility given under the Legal Education Act of ensuring that curricula for training of paralegals in Kenya and setting the standards of paralegals in Kenya is done. This, of course, for us has been supported by the UNDP in the development of the criteria for licensing of paralegal providers in Kenya. That criteria is complete. We shall just planning to have a validation conference, and then we submit that to the Delegated Legislation Committee of the National Assembly, and then it becomes law. Now, the main reason for us developing this criteria is, as I have said, is to set the standard, because we must set the standard. If we don't, then we open ourselves up to cases where we cannot guarantee that legal aid offered by Mary here on a land transfer matter is the same advice that will be given by my friend Flora there on the same land transfer matter, and therefore creating some sort of consistency and the ability to verify that sort of advice to the benefit of the legal aid seeker. That is important. In light of the COVID-19 scenario, the council actually worked very hard during that session. I think by that time we had presidential order number 1 and 2, not to be the naysayer in ensuring continuity of legal education and training in Kenya. Now, what do I mean by that? The council did not want to be the one that says, shut down, take your bags, go home. The council instead asked, how do you intend to ensure continuity? And as I have said, our 6 universities said, we shall use the online programs. They were there, they existed. We shall leverage on technology. We shall go to the open and distance learning school and mount the law program there to ensure continuity. Now, when council realized that the institutions had capacity to do that, we actually allowed the institutions to go as far as assessment. Assess. It got to a point where council demanded that the institution graduate a class of 2020. And most were able to do that. So, in our national quest to remain above COVID-19, to navigate the terrain and the inconveniences caused by the pandemic, we would not want, as a regulator, to be the naysayer in development and advancement towards ensuring continuity. We also are able, as an institution, to devise and implement disaster management plans and initiatives to ensure that we do not cripple or clog the legal aid education system of the justice sector. We allowed off-site registration of our bar candidates, and we were able to offer the bar. 4,000 students converged in 5 different venues, and we did offer the bar. And that for us was quite a milestone and an achievement, because we were able to play our part in ensuring that we have continuity of skill and knowledge getting into the justice system. We support institutions that adopt alternative ways and means of content development and assessment. Institutions that come to us to tell us that we can now guarantee remote access to information, including libraries, and to be able as an institution to go back and change our policy positions about how many core texts are on the shelves, to be able to tell institutions, look, show us that I can have remote access to the library from my home in Murang'a North, and we would be able to give the license. So being able to adapt, I know it looks like we play catch up, but as it should be, somebody sets the trend. And what as an institution we must always endeavor to do is to keep up with it, if not go for it. As I conclude, Council is a part of the justice sector fabric as a core and fundamental duty bearer to ensure access to justice. But even as we go through this conference for the next couple of days, is to be able to look as individuals beyond institutional positions, institutional capabilities, and to be able to have an internal conversation with yourself to ask, what can I do as a person to contribute to nation building, to contribute to the betterment of my society, especially where I can offer legal aid. Ladies and gentlemen, I thank you for taking time to listen to me.
Uh, Thank you so much, Mary, for that wonderful presentation on the need for the question of duty bearers in the justice sector. I think some of the highlights that are coming out is the council's obligations to ensure and assure highly qualified graduates, which I think is still a great issue of concern. The need for regulation of legal aid providers, given that legal aid is standards and the quality assurance issue. And I think lastly, the broader need for regulation for the larger legal education and aid sector. And some of the key development aspects that are in that regard. We will open up the question session later on. The next speaker who we want to invite is Flora Bidali. Flora is the acting CEO, NLAS. She's an advocate of the High Court of Kenya. Um, uh, she's an environmental scientist at Egerton University. She's a former lecturer at Egerton University as well in the School of Gender. And she has a strong interest in matters of access to justice and mediation. So most welcome to her.
Distinguished guests, ladies and gentlemen, those present and those virtual, good morning. It's a special day today, and for me, a very special privilege to be here for the second year running to join follow-up team in this conference. My topic today was National Legal Aid Service, perspective on legal service provision during the COVID pandemic. The National Legal Aid Service, where I come from, is proudly associated to be in partnership with the Egerton University Faculty of Law. We take special cognizance of the presence and the progress that the faculty has made in promoting access to justice for the indigent, the vulnerable, marginalized persons in Nakuru County and its environs. You may be aware, ladies and gentlemen, that matters access to justice have for a long time been the domain of civil society. Government had very little role that it played until just a few years ago when we came up with a program that would start playing a role in access to justice. Come 2010, when we got the Ministry of Justice, as it was then known, a pilot program was started where we piloted in partnership with the civil society to see how we would come up with a mode in which government would contribute or play its role in providing access to justice for the vulnerable members of society. The pilot projects gave birth to the Legal Aid Act, which is now the National Legal Aid Service. As you're aware, or you may be aware, the National Legal Aid Service has a mandate to, among other functions, to provide legal aid services to the indigent, vulnerable, and marginalized in society. This we have been doing using a mixed model. We carry out alternative dispute resolution. We do the mediations, the PRA, the parental responsibility agreements. Those are matters that we handle on day-to-day basis in our office. This we've been able to do because of the partnerships that we have had with the EU, and this has taken us to 12 counties and still running. We are replicating these services in other counties. Last year brought different ways of doing things. We have a new normal way of doing things. COVID-19 pandemic made our social and economic ways of life either totally different or at least not the same as what it was. This led to economic challenges which consequently impacted on the service delivery, and access to justice was affected in a big way. And in combating the COVID-19 pandemic, the legal and policy responses, they had to be developed a way to counter the pandemic. Further, there were job losses, limitation in movement. All this impacted negatively in accessing timely and effective legal service. From this understanding, delivery of legal aid was not provided effectively. However, as the National Legal Aid Service, we also came up with a mechanism in which we were using in order to still play our role to Wanjiko. This was to counter and address the challenges that hampered access to justice. Some of the lessons that the service embraced from the onset of the pandemic included the need to embrace technology in service delivery. The speakers before me have mentioned this over and over again, but it is a technology that really has been embraced, and we can see the difference that it has brought, and it is a system that has to continue, not just during the pandemic, but for a long way to go. Out of this, we have had several discussions with several judicial officers, especially the magistrates, where we are getting to have these virtual hearings with our pro bono advocates. Those of you who have worked out of in the marginalized areas like Marsabit and Isiolo, where we have funding from the European Union, will understand and also know that we have limited advocates in these areas. But embracing technology has helped us to address the challenges that we are having in providing access to justice. We've also noted that there's need to capacity build the local authorities. We are talking of the chiefs and village elders to promote and support community-based dispute resolutions. These are the people who are at the grassroots level, and they are the people we rely on in order to provide access to justice. Then there's creation of awareness to members of the public on their rights, the importance of embracing technology, and disseminating legal information. This has not been done in as much as it's being done in the urban areas, but in the northern areas, in the marginalized areas, this has not been done as intensive. We are also embracing alternative dispute resolution. This is a role we are playing in order to reduce the backlog in cases. There's need to educate public on emergency issues and what is required of them during these emergencies. We remember baby Pendo in one of these emergencies, and we need to educate the public what is their role and what should they do when the duty bearers have overstepped their roles. There's need to create an oversight authority to oversee the implementation of emergency measures to reduce excessive use of power and exploitation of civilians by the duty bearers. Then we also note that there's need to embrace and recognize community paralegals who assist in service delivery at grassroots levels, and to also assist in providing legal aid during emergencies. Then we also look at the need to develop an effective economic support to the indigent, vulnerable, and marginalized persons during emergencies to enable them to sustain themselves. As a service, we have been embracing this, what we have seen on the ground, what we have shared with our stakeholders. We have come up with various ways of providing services to Wanjiko. Honorable Wasilwa talked of where the clients are going to the cybers to have the e-hearing and the e-trials and e-filing. When it is a hearing, the background, they have no control over it. As NLAS, we have come up with booths where we are facilitating for these hearings to take place with limited interruptions. We also assist these clients in opening their email addresses. Those of us who are here all have email addresses, and we take it for granted that it's a simple thing, but it is not. When you are doing the access to justice programs, you will come across challenges which, with a touch of a button, you will have assisted an indigent person to access their rights. We also encourage our clients to use our toll-free line. FOLAP started it and we followed. We are sharing information with stakeholders. This toll-free line has been very active, and it helps us to reduce the crowds that we have in the office, because there are matters that we can address through the telephone. For instance, directing them to where our offices are at an agreed time. We have been engaging our clients through radio talk shows on various topics: family matters, sexual and gender-based violence, children's rights, property, and land laws. During the times that we have had these radio talk shows are the days that our toll-free line will be jammed with calls. We have learned that we should never have these radio talk shows over the weekend, because our toll-free line for the moment is not operating on the weekend. So we try to make our radio talk shows during the week when we will receive a high number of calls streaming in. We also developed a duty rota to book clients on appointment basis, and this has been quite effective. Ladies and gentlemen, despite the efforts that we have made, we note that there's still a lot to be done. In the meantime, we are working to ensure that our services to all deserving Kenyans are still rendered with high professionality level. For this reason, we embrace partnership with organizations dealing in access to justice. Our presence in this conference signifies the endless partnership with FOLAP. We have been key, FOLAP have been key in the delivery of justice in Nakuru County and its environs. As NLAS, we have partnered with them on several activities when delivering justice. We are grateful for the opportunity to participate in this conference, and we thank FOLAP team for this invitation. Earlier on, each of one said our expectations from the conference. As NLAS, our expectation is to learn from each and every one of you. We've come from different organizations, and each organization has a different way of rendering access to justice. We hope to learn from you the different ways, implement the most effective route that we will use to cater for access to justice to Wanjiko. We also look to partner with all those in matters access to justice. I'm happy to share with you that the support we are having from government is wide. The the support we got from the EU for the 12 counties. Having visited the 12 counties, we have been allocated offices in each of these counties from government, our government sector. We also have offices which have been offered to us, and it's a question of time when we will also have personnel in the other counties where we render our services. We have full support from the Office of the Attorney General to render these services. The partnership that we get is encouraging, and this partnership will make us proceed with the services at the best level that we can make with this. Before too long, we hope to delink from the Office of the Attorney General and be a state operation independent. The advantage of this is that we will be able to render our services in a faster way. We will be limited in the number of bureaucracy stages that we need to go through. This will expedite our services. We are at the tail end of finalizing our human resource instrument, which will then allow us to delink and render the services to Magure and also go into more partnership with those providing access to justice. Once again, I say thank you very much for this invitation, and I look forward to a fruitful week where we will learn from each other. Thank you very much.
Thank you so much, Flora, for the voice of National Legal Aid Services, and speaking about some of the institutional measures that you've adopted in ensuring the broader delivery of access to justice in Kenya as a statutory mandate. I think you've highlighted how AJ was once the domain of civil society, but I think upon the institution of National Legal Services, it has become one of the governmental activities through the then Ministry of Justice. You've highlighted some of the institutional support to those who are involved in the AJ system by your institution, and how in the recent past you've been embracing ADR to help reduce backlog in the courts and promote the broad access to justice. You highlighted the measures of promoting access to justice of various kind, administrative issues such as toll-free lines, duty roads for taking clients, and so forth. And you have expressed the great aspiration to partner with all those who are involved in the alternative justice sector, which is an appeal to those who would be offering assistance and cooperation in this noble cause. And thank you so much for keeping time. I think we're moving so well. The next speaker, I don't know whether he's online. The next speaker is Dan Juma. I don't know whether he can hear us.
Good afternoon, Dr. Miyawa and colleagues. Can you hear me clearly?
Yes, I can hear you. Most welcome. Dan Juma is here to represent Mr. Walid Badawi, who is the UNDP Kenya resident representative. And by way of introduction of Dan Juma, who is my personal friend as well, I was able to get this through a search engine. You will correct us if this is inaccurate. Dan Juma is the team leader, governance and inclusive growth, UNDP Kenya, where he joined in 2019 as the team leader, governance and inclusive growth. He leads the UNDP's programmatic support to national development priorities, covering deepening democracy, human rights evolution, civil society and citizens engagement, transparency and accountability and peace, and social cohesion, which is, broadly speaking, all access to justice of various kinds. And to go to his academic credential, Dan holds a doctorate in juridical science, JSD from Harvard University, a master's in laws from the London School of Economics, a Master of Arts from the United Nations mandated University for Peace and a Bachelor of Laws. Now you understand why Dan will not be running for any seat in Kisumu. Feel most welcome, Dan.
Thank you very much. I hope that the other machine is muted so that there is no echo. And thank you very much for the very kind introduction. The DVC, Egerton University, Professor Boklina Bebe, Dean Faculty of Law, the Honorable Lady Justice Helen Wasilwa, who I think has left earlier on, CEO of the National Council of Legal Education, acting, Ms. Mary Magure, the ED of the NLAS, who's just spoken, Ms. Bidali, Professor PLO Lumumba, and distinguished members of the academia, including the students who are part of this, representatives of civil society organizations, the EU representative, Alexandre Baron, and my colleagues from UNDP. Ladies and gentlemen, good afternoon. It gives me really great pleasure and honor to make these remarks on behalf of the UNDP resident representative. Apologies, I see I could not put on the video, but I think that is from your side, so you can't see me. It would have been great for us to see each other. But let me begin by extending a particularly warm welcome to our distinguished speakers who are slated to present their work at this conference. Let me also, at the outset, express our gratitude to the European Union, represented here today by the Head of Governance and Macroeconomics. I think it's really befitting that this conference is reflecting on the question of justice, which is not only a pillar of governance and a service, but an ethical and political imperative that underlines the very foundation of the United Nations. If we were to talk jurisprudence matters, and I know there are professors here, I think we would be nearing mentioning the concept of Grundnorm by the Austrian, but also the UN legal expert Hans Kelsen, who spoke of the Grundnorm. And I think if you look at the UN Charter, the preamble, it is really an affirmation of we the peoples committing ourselves to establish conditions under which justice and respect for the obligations arising from treaties and other sources of international law can be maintained to promote social progress and better standards of life in larger freedom. As you may be aware, the UN's primary mandate is to work with member states towards realizing transformative development aspirations to ensure better choices and capabilities for all. In doing so, our compass is the Sustainable Development Goals, the SDGs, which provide a framework for guiding efforts towards promoting sustainable human development all over the world. Realization of human rights and access to justice are indeed vital components in the quest for sustainable development. Now, it's very clear from the presentations we've had that people encounter justice problems in nearly every aspect of life. So whether it's in relation to their health or whether in relation to their education or housing or employment or land or related livelihoods, the access to justice problems that people face in this country are very, very clear to us. And therefore, that is why this conference is gathering to see how it is that we could address some of those issues. I recall the Kenya Integrated Household Budget Survey of, I think, 2015, 2016 really highlighted this and brought them down to the county level so that one can be able to see in Tharaka Nithi, for instance, what are the justice problems? In Nairobi, what are the justice problems? In Mombasa, in Kisumu, that I had mentioned earlier on. Therefore, it's in that font that SDG 16 enjoins member states to peaceful and inclusive societies by providing access to justice and building effective, accountable, and inclusive institutions at all levels. Without strong guarantees for access to justice, particularly for the poor and vulnerable, as we've heard previous speakers allude, without citizens' voice, choice, and opportunity to access resources and participate in governance will remain at risk. It is therefore laudable that through SDG 16, the international community and member states, non-state actors have committed to achieving access to justice for all by the year 2030. But we know that the theme of this conference is a reminder of the collective action that is required towards peaceful, just, and inclusive society. Now more than ever, COVID-19 has exacerbated the obstacles to justice, which we all know, the widening structural inequalities that have been caused by the socioeconomic fallout from the pandemic, the recurrent violent conflicts that we see, the shrinking civic space, and so on. I think to this, one may add gender-based violence, alluded to already, the human rights violations that were brought about during COVID, and the further marginalization of already existing marginality. The point of highlighting the justice gaps that have been created or worsened by COVID-19 is really to challenge each of us that we simply cannot let this become the new reality for many. Therefore, the message from UNDP is very simple. We must act now, and we must act together. To guarantee realization of sustainable development, we must dedicate our efforts on access to justice, rule of law, and human rights, with a laser-sharp focus on where we can have the most immediate catalytic impact through solidarity, which is a word that I've heard coming out very clearly throughout the past session. This call to action is one which this conference promises to unpack through meaningful conversations about what is and what ought to be. A review of the papers slated to be presented for the next couple of days confirms the promise, and up to now is the promise on how we can unlock innovation-driven access to justice solutions, including digital legal services, but making sure, as we know, that no one is being left behind, and I think that issue is already coming up. The use of technologies such as helplines and other specialized justice and protection services aimed particularly at women and children. Channels for accessing justice through alternative justice systems, frontline justice workers such as paralegals, low-cost mediators, and so forth. Globally, the UN and UNDP continues to work with governments to strengthen the justice sector through formal and informal institutions in ensuring expedient delivery of justice services. These interventions are underpinned by a human rights-based approach, emphasizing participation, accountability, non-discrimination, and equality, empowerment, and legality. The UN human rights system, complemented by a regional instrument, in addition to our constitution, provide really a strong normative framework for access to justice, guiding our efforts to address the underlying and root causes that impede effective and timely access to justice. This certainly is work that requires collective action. UNDP continues to collaborate with sister agencies, particularly the United Nations Office of Drugs and Crime, UNODC, in working and partnering. Partnering is really the key word here, with state and non-state actors to effectively implement the normative principles I've highlighted above. If we relate this to the subject of this conference, I invite you to read the guidance note done not long ago by UNDP and UNODC, and you can find these online on access to justice in times of COVID-19, but still another publication that also looked at the gender dimensions of access to justice during COVID-19 as we have this conversation. We acknowledge that building the capacity of governments and judicial authorities is certainly a strategic priority, but is by no means sufficient to addressing the justice gap. It is for this reason that UNDP is very happy and proud that we are working with civil society organizations and academia. I think as we were doing our legal studies in the late 90s, early 2000s, there were quite a number of, legal and human rights institutions, Lep Sharia, Sala, and so forth. And really good to see that this space is being regained by the admission of the Egerton University School of Law, but also the University of Nairobi School of Law, Mombasa campus, which is now also one of the grantees under this program. As I come towards the end, and as already highlighted by my colleague who spoke earlier, I will not repeat that. Let me just say that we take access to justice promotion as central to realization of the strategic priority of accountable and inclusive governance. Through the civil society strengthening facility, we have since 2008 built the capacities of civil society organizations in legal aid provision and awareness. Currently, we are co-implementing together with FLEED the Program for Legal Empowerment and Aid Delivery, FLEED, which is a 5-year program, and we are hoping that there will be a second phase to it, which I'm sure the representative of the EU might speak to. But we are thankful to the EU for the financial support from them. Notably, really, we try to make this to be consumer and demand driven, and I'm sure that as we work towards the new program, we will be getting some feedback from yourselves on how to leverage the town and gown, the town meaning the civil society organizations and communities, and the gown meaning the academia together. From these initiatives, UNDP appreciates the need to promote sustainability of legal aid and awareness promotion beyond current funding streams. And so we hope, and I have in front of me last year's conference, 90 pages of abstracts. And we hope that as we go into the third conference next year, we will already be beginning to think about those issues of sustainability, which I believe are already being thought of in terms of how to make use of the products that we get here, policy action, practice, and really making the impact on the lives of the people we work with. At UNDP, actually, we consider ourselves not as donors, but as part of a community, a systemic community that can harness knowledge generated, that can provide thought leadership and technical assistance in areas of understanding how best to unlock access to justice, and working obviously with practitioners and development partners to target the resources that can leverage this. As I end, as you gather in Timberlodge for the next few days, I urge you to foster healthy and robust debate around the ideas to be presented at this important conference. UNDP and our sister agencies, UNODC, I believe they were supposed to hear, but they might have not been able to, look forward to disseminating the publications that will spring from the presentations to be made. And we hope that we can channel this really towards policy action, and that is why it was really great to hear from the duty bearers, the NLAs, and the CLE that spoke earlier for me, and of course the practitioners, the lawyers themselves. Allow me to congratulate again Egerton University's Faculty of Law, led by Dr. Ruth Aura. I see also Dr. Miawa is here, and all the other colleagues who are really helping to move forward this Faculty of Law Legal Assistance Project follow-up, for leading the organization of the second National Legal Aid Conference. Let me thank once again our development partners, particularly the EU, who has enabled this conference. I wish you fruitful deliberations and look forward to continued partnership towards improving access to justice in Kenya, particularly for the poor and vulnerable. Asanteni sana.
Oh, thank you so much. It's Noah. Thank you so much, Dr. Dan Juma. Thank you so much, Dr. Dan Juma, for that technocratic presentation, highlighting the reasons for and why UNDP deems access to justice as a very crucial component of delivering development, because development has got various dimensions: human rights dimensions, environmental, and even criminal dimensions. So it's laudable that UNDP deems access to justice, and particularly the processes and the enablement through Egerton University at this stage. Of course, your presentation was quite on a number of areas that I may not want to go into right now, but we appreciate. Some of them we'll highlight during the question session for those who may be interested in questioning further why UNDP may think this is a very important exercise. We are going to invite the next speaker, who is Mr. Alexander Baron. He's the head of governance and economics of the EU delegation in Kenya. Mr. Baron, feel most welcome, and we are attentive to your presentation.